Good morning, good afternoon, and good evening to all, and welcome to Khaitan & Co. and DLA Piper's joint webinar. My name is Gitanjali Bajaj. I'm a partner in the Construction Disputes and International Arbitration practice of DLA Piper based out of Sydney, and I'll be your moderator for this evening, joined with my associate from my team, Sanjana Pramod. Now, for today's webinar, we have a very exciting and diverse group of panelists lined up for you from India, Australia, and the UK, who will share their thoughts on the recurring themes of delay and cost overruns that the construction industry has faced across every jurisdiction as a result of the COVID pandemic. They'll also share their thoughts on how to best navigate these. Now, going around the virtual table for a quick introduction of our speakers. And speakers, please feel free to wave out to our audience. We have first Mr. Venkataramana, Vice President Legal of Tata Projects, India's leading engineering and construction company, active in almost every construction sector you can think of, from power to water to oil and gas, transportation, and urban infrastructure. Then we have Mr. Martin Hunter, who is the co-founder and managing director of Yendall Hunter, a construction dispute and advisory firm that provides expert support services for cost and schedule analysis. We have our two partners from Khaitan & Co., Mr. Raj Panchmatia, partner in the dispute resolution practice based out of Mumbai, and Mr. Sudeep Malik, partner in the real estate and construction practice of Khaitan & Co., based also out of Mumbai. And finally, our two DLA Piper partners, Mr. Paul Giles, who's the co-head of construction disputes for DLA Piper, based out of London, and Mr. Richard Edwards, who is the other co-head of construction disputes for DLA Piper, based out of Perth, Australia. Now, before we move on to our Q&A, some very quick housekeeping. There will be a Q&A session with the audience towards the end. But you don't have to wait till then to send us your questions. You can send us your questions by typing them at any point in the question box in your webinar portal. Now, many of the attendees have actually already sent us some questions during the time of registration, and some brilliant questions. Thank you for that. What we will do is we'll endeavor to pick those questions up during the session itself. You'll see many of the questions is what the session is meant to be answering and hopefully answer for you. And lastly, this webinar is being recorded, and the recording will be emailed to all of the attendees after this session. So now, moving on to our Q&A, Venkata, I thought I would start with you for the general question for you. Now, in March last year, the Home Ministry of India, of course, issued guidelines imposing a nationwide lockdown. Most construction activity was prohibited during this time. As a result of these measures, India witnessed a mass movement of migrant laborers. Now, Tata Projects, as I mentioned, works across almost every single construction sector. What we wanted to know, Venkata, was whether you found that there were common themes in terms of the main challenges that your business faced across these sectors, or whether one of the sectors was affected more than the other. And if that was the case, then why?
Thanks, Gitanjali. Thanks for introducing me, and happy to be part of this privileged panel and this webinar. Let me start by telling you that the Government of India guidelines that were given has affected the sector as a whole. You know, there is no difference between one sector and another sector. But I think the projects which are being executed in urban areas are more affected than the rural areas. And it also depended on the stage where the project is situated. The projects which are in a very early stage, in the design stage, they were not so much affected. So that is one part of it. Coming back to the question of the common theme, I think the most important thing we were faced at the initial stages was whether COVID itself is a force majeure situation, whether the contractor is entitled to raise claims under force majeure, or whether the notifications issued by the Ministry of Home and the guidelines that are issued with respect to quarantine, with respect to lockdown, come up within the purview of change in law. I think, as most of you are aware of, both the FIDIC forms of contract as well as the bespoke contracts that we have. The entitlement for a contractor, if in a force majeure situation, is only the time. Costs are not tenable. So that is the reason I think most of the contractors, we choose to go and invoke the provisions of change in law, because change in law entitles us for both costs as well as time. And we went ahead with that particular provision. Initially, there were also questions whether the notifications issued under the Disaster Management Act itself come with a force majeure clause or not. But most of you are aware the FIDIC definition of laws and legislation is quite wide, and even subordinate legislation and notifications issued invoking Disaster Management Act come within the purview of force majeure. That is my, come within the definition of change in law. That is my personal opinion. And another view that has been taken is even the change in applicable standards or the process to be followed, the number of people to be employed are reduced. All these also comes within the purview of variations, and that we are still to explore how this particular thought moves forward. And with respect to the claims itself that were launched, I think the engineers are yet to determine most of the claims. But some of the employers have been very proactive, and in the interest of the project, they have granted time, and they also granted reimbursement of wages that were paid by the contractors pursuant to the orders of the Ministry of Home Affairs. That's
Thanks, Venkata. And it's interesting, the themes that you've just recounted. So when I mentioned earlier that we had questions at the time of registration. Out of the 18 questions we have, most of the questions were actually just directed towards what do you do when force majeure is only giving you time and not costs, or can you actually have change in law in terms of the regulations that were being passed, and of course making use of variation. So it's very much, as we said, it's a common theme and common trend. So just following on from that, Raj, following on from those observations, would you say that this resonates across all of your clients and across all of the sectors equally?
By and large, because as you know, once the pandemic hit, most of the construction work came to a grinding halt as an immediate knee-jerk reaction. All work sites, every construction activity was brought to a standstill. Thereafter, depending upon whether any activity was deemed as an essential services and was allowed to continue, certain carve-outs were made and certain projects were allowed to start and continue. And again, there was not, as Venkat rightly put, the impact was different in different parts of the country. Say in the rural areas, you were allowed to carry on work. In urban areas, there were far more restrictions from carrying on the major project works. But yes, there was an impact. We also saw a lot of impact, especially in the urban areas, because of restrictions on travel. So a lot of employees, a lot of labor class, a lot of labor who was actually working at the work site could not reach for doing their work. But there was a huge migration issue. A lot of people decided to migrate, and therefore there was a huge migration issue. A lot of problems in relation to transportation facilities because of the lockdown. A lot of facilities, transportation facilities were not available. Like, for instance, the trains were not working, metros were not working. The people who were in far off areas, like engineers and others, who had to come and report to the construction site, could not reach on time. There were notifications from the government which allowed the construction workers who were in situ, so those who were present at the site, carry on the work if the site was found within the essential requirement project. They were allowed to carry on, but otherwise there was a grinding halt. All of this also led to a lot of delay, cost escalation. We saw regular claims coming in for that, extension of time. A lot of clients were asking whether this would amount to be a change in law, whether they could, other than extension of time, could they ask for cost escalation. These were regular queries, and most of the clients were facing this issue. Another issue that probably the clients were also facing was a lot of cash flow issue. Because of the sudden lockdown and no revenue coming in, a lot of big infrastructure clients also started to face cash flow issues, which also resulted in a delay They had to pay huge idling costs. Their overheads were going on. They were required to make. They were required to pay salaries to the employees and the laborers. So there were multiple issues that we saw that the clients were facing. So I think the issues across the sector, across clients, were predominantly the same.
Thank you, Raj. And Paul, would you say it was the same experience in across Europe?
Yeah, I mean, so there's a lot of similar themes that are coming out from what Raj and Venkata have just spoken about in India as well. So in Europe, well, let me start in the UK, I guess. That's probably easiest. I think there was two clear phases in the UK. The first phase is probably one of utter confusion and uncertainty in the construction industry. There were these government edicts to suddenly stay at home, and there was a lot of confusion for what that meant for construction. And that first few weeks, guidance after guidance after guidance came out as to what that really meant for the construction industry. And what the guidance meant versus what actually happened was probably two different things. So initially, the construction industry effectively shut down for that first couple of weeks. And then the government clarified they wanted the construction industry to continue as a real economic driver. The reality was the construction industry wasn't quite ready for that, and so took a good period of time to work out how they were going to get back to work. And of course, with small subcontractors having initially shut down and concerns over safety, then there was a real period of uncertainty before things got back going again. From a contractual perspective, the points that Venkata and Raj made in terms of the immediate rush for force majeure notices to be submitted to try and protect commercial rights, you know, that absolutely happened in the UK as well. And you ended up with this slightly strange position where contractors are serving force majeure notices, but the government is saying carry on working. There's no need to stop. So there's that theoretical entitlement arising, and then, as was mentioned by Venkata, then there's the move towards change in law. The understanding actually change in law generally gives you time and money, not just time like force majeure, and so a desire to protect the commercial position with new set of notices on change in law. But of course, it's all about the same disruptive effect, really. One of the themes in Europe and even within the UK was the regional differences. So I don't know quite how the regional differences worked in India, but I mean, even within the UK, we had Scotland, which generally took a harder approach than England, and so Scotland construction work was supposed to stop except for essential projects. So healthcare projects would be a good example of that. In England, everything was supposed to continue. So again, adding to that sort of uncertainty as to project, and of course you've got cross-border workforces moving in and out of the different regions. So that period was definitely one of uncertainty, I think, and took a good month to 6 weeks to settle down. That UK model is probably reflective of Europe generally as well. Europe, obviously a huge amount of countries, different governments took different approaches. You range from the Swedish model, which was very liberal, I suppose you would call it. There was no real formal lockdown in Sweden, to perhaps the French and the Spanish and the Italian model, which is very severe lockdowns with all construction work stopping. UK probably towards that end of things. But to pick up on the themes, so to go back to your question, I guess, very similar problems to what's been talked about India, the government in the UK and in Europe generally has issued repeated guidance as to how construction industry should work. Unresolved claims, Venkata mentioned that engineers avoiding making a decision, employers avoiding making a decision, absolutely still the case, even sort of what 8-9 months on. Labour material shortages issue, which Raj touched upon, absolutely that, and you know, the change in law point we'll probably touch on a bit more in due course, but change in law where was also a massive issue. You know, the supply chain in Europe particularly, but I think globally, is so international now. The extent and scope of that change in law question was quite difficult. Other point is things have been delayed, no question, but have they really been critically delayed? Have they really caused extensions to the completion date? Depends very much on the project, on the sector, and what was going on at the time. But yeah, a lot of them similar themes, I think.
Thank you, Paul. Richard, I'll just get you to give us a brief APAC perspective as well before we deep dive into some of these issues of change in law and also some other things that Paul just mentioned about critical delay, disruption, concurrency, etc.
Thanks, Gitanjali. Well, as most of you might know, the Australian experience has been substantially different from the experience of many other countries, many other regions. Fortunately, Australia as an island nation was able to lock its borders very quickly and did so. The consequence of that for the Australian construction industry was minimal disruption, minimal real disruption in terms of infrastructure projects. That was especially so because for state governments, territory governments and the federal government, social infrastructure in the form of roads, hospitals, tunnels, sports stadia are all seen as existing in a special place in the hearts of Australians and Australian taxpayers, and the message was given very quickly that Australia should continue building. The consequence of that was that most, if not all, construction projects continued almost undisrupted. Asia Pacific as well has been fortunate so far, with some exceptions in terms of the construction sector. If you talk about Korea, if you talk about Indonesia and Thailand, the low COVID numbers has meant a continuation of relatively vibrant economic activity and therefore little true interference with progress and execution of works. The exception would be Singapore, where its reliance on migrant workers did have an impact, particularly in circumstances where COVID, in terms of COVID hotspots, that migrant workers were identified as one, and there were various directives locking down migrant worker accommodation. Fortunately for Singapore, that seems to have resolved itself. Indeed, the Singaporean government late last year took what some might say is extraordinary measures to proceed to legislate for certain matters, including a legislated extension of time of 122 days on construction contracts in Singapore. So you've still got a varied response, albeit that COVID has perhaps not had the impact. The really interesting question for this region is going to be what happens from here, particularly as we are starting to see breakouts in places such as Indonesia, Thailand, Korea, which so far had appeared to manage the pandemic well.
Thank you, Richard. Sanjana, over to you.
Thanks, Gitanjali. So to tee up the conversation, I'd like to explore entitlement across construction contracts. I think it's safe to say that across all jurisdictions and different types of contracts, parties have primarily relied upon three main claims, these being force majeure, change in law, and extension of time clauses. In fact, most of the audience members have submitted queries relating to how best they can use these clauses in their contract to obtain relief from COVID-19 impact. We'd be very interested in hearing some success stories where the panelists have been successful in obtaining relief by invoking these clauses. So Sudeep, I'd like to invite you to provide your comments from an Indian standpoint.
Thank you very much, Sanjana, for the question. And first, let me tell you, I will restrict myself to the Indian scenario. As you all know, we mostly have indigenous contracts and not standard form contracts to deal with. So each and every contract will be different. It is correct to say that while we are dealing with a situation like COVID, the most important clauses are change in law, force majeure, and of course your extension of time clauses. But what we have seen is when clients started coming, I represent mostly the contractors. So when clients started coming to us, they had already issued notices relying upon the force majeure conditions and the terms of the contract. Now, if that was the situation, then we had to claw back to see, because you see, in most cases, force majeure will allow extension of time and no money. But because this situation required extra payment to workers, maybe additional cost that was to be incurred, contractors were exploring as to what would be the best mechanism for getting those entitlements. So one would look at change in law provisions. Change in law provisions generally are very narrowly drafted in India, So we took recourse to other terms and conditions in the contract itself. Now, if it was a COVID-like situation is covered under the change in law, force majeure, or extension of time provision, then you are bound by the terms of the contract. But if it is not covered, and you have to draw inspiration from other terms of the contract, what we help client, you see, nothing has concluded yet. Whatever I am telling you is this was the starting point of conversation with the engineer in charge and the employer. The way we help to construct is that we found out provisions like applicable laws. A contractor is required to comply with all applicable laws. Now, once we started investigation, the first point is that how can I comply with an applicable law which I knew or which I did not know when I entered into the contract will come into force. Then whether the circulars that were issued pursuant to the during COVID times under the Disaster Management Act or the Epidemic Diseases Act, whether those notifications had the force of law. Now, after investigating those, then we came and said, well, you are entitled you have an entitlement. That was the starting point of the conversation. Whereas the owners or the employers originally said, get lost. We are not supposed to give you anything. It is a force majeure situation. Now we have arrived at a situation where the employer said, okay, maybe you have a case. Then we looked into how the owners conducted them, whether they issued statements like please stop work. Now, then it is again a different provision. In another case, what we saw was where there was a suspension provision by the owner. Now, the suspension provision also, if it goes beyond a particular point, entitles gives the contractor a termination. So those recourses were looked into, and therefore we could push back the owner in saying no, that we are not entitled to anything. Please have a relook at it. And the owners themselves realized that yes, that it is not such a simple situation to say, well, this was a force majeure, your own time only entitled to extension of time and nothing. So that position has been secured. So now we are now in a much better position to get back our entitlement as a contract. So these are some of the live examples.
Thanks so much, Sudeep, for that detailed answer. I think it really helps to caution parties not to just jump to the force majeure clause, but in fact, look at the entire contract as a whole and also try and interpret the latest circulars and other subordinate legislation and weave that in to a change in law clause. I think that's very helpful.
I'll just add one more thing which I forgot and which I remembered, was that when you are doing something extra for the owner, which you are not supposed to do. Section 70 of the Indian Contract Act, which is an application of quantum merit, that you do not want to do so gratuitously, you are entitled to be compensated. Now, going one step further, whether when you are doing an arbitration, starting with when you are getting into an arbitration, all dispute arising out of a contract can be arbitrated. Whether a quantum merit claim can be arbitrated or not, yes, it can also be arbitrated. There are old judgments to that effect. So therefore, you will have to look at the whole thing when you are forming your own strategy.
Thanks so much, Sudeep. Richard, over to you. How have you been helping your clients in APAC ride out the wave? Are you adopting a similar approach to our Indian practitioners, or is the situation vastly different in Australia?
Indeed. Thank you, Sanjana. Look, the approach is largely the same. I think regardless of the form of contract being used, the concept of force majeure, the concept of variations, the concepts of extension of time are common. The change in applicable law is also common. Fortunately, my clients, like many others, have had access to literally tens of thousands of publications by lawyers and construction consultants and other wise people about various straightforward and more complicated ways of pursuing claims for entitlement. So there was no doubt from very early on that contractors who had some level of financial and contract hygiene about them were in a position to make claims. The lived experience here is the same as elsewhere, which is everyone reached for force majeure to begin with. They then thought, oh, maybe there's an applicable law change depending upon what sort of legislation you're dealing with. And as situations have developed, contractors in particular, subcontractors have sought to adapt their approaches. For example, one client approached us at one stage last year asking whether directives issued by the PRC provincial authorities about shipment of goods out of China would be a change in applicable law under an Australian contract. So you're in a position where those contractors who perhaps haven't looked after their interests early, haven't identified an astute way of proceeding or hedged their position with an employer or principal, are now searching around trying to figure out how best to deploy and create a strategy that is effective.
Thanks so much, Richard. Looks like there's a lot of room for creativity on how you can maneuver and come up with various strategies to combat the impact. Paul, would you care to briefly elaborate on the situation in Europe and how you've been advising your clients? I think you're on mute.
I was sorry. That was obviously schoolboy error for a webinar. My apologies. So yeah, I think some very common themes coming out, which perhaps isn't a huge surprise. As I mentioned a bit earlier, we had the rush to force majeure, then the change in law. That seems to be a common theme. I think in the UK and in Europe in particular, the change in law claims are extremely complex. And what I mean by that is we have had laws issued in relation to how people should behave during the pandemic. And then there is guidance. I think Venkata mentioned, the subordinate legislation that is probably called a FIDIC type contract. Some of our contracts would include some of that type of legal, some of that type of legislation. Some of them won't. Some of them will include guidance issued by government, but not others won't again. So there's a really mixed approach depending very much on the contract and actually the project and the sector as well. One of the things that happened in the UK was that the government issued some construction industry guidance, which was essentially saying, look, COVID's a difficult situation. Can you all be nice to each other and act in good faith towards each other? but expressly said that didn't change anything in the contract. So again, you know, lots of this sort of clarification and soft law versus hard law, and that's a real problem, real challenge in terms of, again, in theory having a contractual entitlement, but then in practice, how do you demonstrate? And so we work both sides, the contractor and employer client side, through this pandemic, and so we've seen the arguments on both sides, and they are difficult on both sides. There have been a number of compromises and settlements as to entitlement, and I think that's positive generally for those parties involved, because that gives a degree of certainty. But as I touched on earlier, I mean, there haven't been many formal claims yet, and employers, engineers are taking a wait and see approach, which is perhaps not unusual. I mean, from a contractor side, you would probably say that's a common theme across many construction projects. Wait and see is a better strategy for the engineer, for the employer, if they can do it, because when you start dealing with delay claims, as Martin will talk about later, you know, maybe a retrospective approach is a bit more favourable towards the employer than a prospective. To take one example though of how complex change in law claims can be, we also advise on English law claims overseas, so on overseas projects. And one example where there's an international is where on an energy project there has been a massive change in law delay claims, so over 18 months, which is interesting because obviously that's 18 months in around about 9 months period of time, and much of that is based on a change in law which largely revolves around the need for the workforce to quarantine as being the key change in law when they're coming in and out of the country. But the employer's taken the strategic decision on that project that they will pay for the quarantine period, they will pay for the accommodation for the quarantine. And so you have then a massive challenge as a contractor is, well, if the quarantine's paid for, the time is paid for, and the accommodation is paid for, where's the actual delay? And the contractor on that one is really struggling to pinpoint the change in law to the impact on the project. So I think causation for me is a really significant issue, and it might be something Martin will touch on in more detail from a delay analyst perspective, which is all of these theoretical entitlements are you know, out there, I think, and it's fine being creative. But ultimately, it's about the facts. You know, really, what is the actual delay, and how do you demonstrate that? And as I said, from a UK European perspective, many of those claims haven't started to come through yet, but we're seeing that position starting to develop.
Great, thanks so much, Paul. I think we're all wading through the same waters in the same boat, so there's comfort knowing that, with a few dissimilarities. I'll leave it to Gitanjali now to take it forward.
Thanks. And Paul, you perfect segue, because my next few questions are for Martin, because as you can imagine, most of the questions that came through were specifically on how do you actually prove the delay or the disruption, and what happens if there's concurrency, but you're also impacted by COVID. So starting with delay and concurrency first, Martin, when it comes to assessing delay, there are of course many ways you can skin the cat, but depending upon the correct interpretation of the EOT clause. But generally, however, with all of the COVID delay related claims analysis that you've been doing recently, is there any particular delay analysis technique which is more suited, which would make a COVID related delay claim, say, more successful? And could you also just touch upon the impact of concurrency and what happens if there is concurrency issues and there's COVID related delay events?
Thank you, Gitanjali. obviously quite a lot that we could cover in regards to that question. We know more and more contracts are trying to determine how one should go about analysing delay. So obviously your contract may tell you how you should go about analysing delay, whether that might be prospectively or retrospectively. But as a general rule, the techniques required to analyse COVID, I would say, are no different to any other type of delay analysis. It's an event, it's a delay event like any other delay event that's encountered on a construction project. Assuming there is no requirement set out under the contract, really any delay analysis looking to prove the impact of the COVID event should be with reference to best practice. And for me, best practice is one that's based on common sense, very much driven by the facts, as Paul already just mentioned. When we're looking to assess the impact of COVID, we need to look at the programs that were in play at the time the event started. We need to establish what was on the critical path at the time the COVID event started. And we need to, as Paul mentioned, we need to look at the continuing impact of the COVID event in relation to all other events that could be impacting the project. And that may well change, given the length of time that COVID has been around and continues to be around. Things can change quite quickly in terms of the impacts on the project itself. So for example, when the COVID event started, it may well be that events on the site very much were driving completion of the project. It could be, for example, getting out the ground and getting the civils complete was driving completion of the project. However, because of the impact of COVID, procurement then becomes an issue, and delays in getting materials, for example, steelwork to site, particularly if that steel was coming from overseas, could then have a much bigger impact on the project moving forward. And as Paul said in his just recently in his answer, people are tending to take a wait and see view as to how these events are impacting. And if one waited until the very end of the COVID event and said, well, the impact was X, and at the end of the period, this is what was driving completion, that won't tell the whole story. You have to tell this whole story as to how the impact started and how that impact developed over time and how ultimately it ended up in the overall impact to the completion of the project. That would be important to, under the contract, the contract sometimes will ask you to determine at a given point in time. If you do that, you can only determine that based on the facts known at that time, based on the project progress at that time, in the context of everything else that was going on. One thing that we see in terms of concurrency, and I noticed a lot of questions on this, how do we deal with concurrent delay? Well, obviously, again, contracts now try to determine in a number of instances how we deal with concurrency. It's also a matter of law as well, depending on the jurisdiction that you're operating in, may well determine how you deal with concurrency also. From a delay analysis perspective, again, it's a matter of analysis to determine whether an event was or wasn't critically concurrent. You can have concurrent delay that isn't critical, but it may well be that that could become relevant based on what the contract says and also the legal jurisdiction that you're working in. But for me, from a delay analysis perspective and how that might feed into quantum, then one would be looking at the relative criticality of the events and the extent to which those events were truly concurrent, i.e. critical, at the same time as the COVID event was being experienced.
Thanks. And just on that then, actually, that's a good segue, Martin, about criticality. And you would have seen that there were quite a few questions on disruption as well. Where have disruption claims figured during the pandemic? Has it become a bit more popular? Because one would think there would be an uptake in such claims where you can't establish your extension of time, but you can surely argue that the restricted number of personnel on site, not being able to use the right quality of labor due to border restrictions or social distancing requirements, there's been a significant impact on productivity. And while it might not be critical delay, it has led to non-critical delay and major disruption.
The work that we do as a firm mostly is in the arbitration field, so we haven't seen so many of the disruption claims coming through so far. certainly, for example, in the UK, where you have the adjudication process, that's a mechanism by which you could quickly try and get an award. Looking at disruption, and you're right, Gitanjali, when we look at disruption, we could be looking at critical sequences of work which were impacted by disruption, so lack of productivity, inefficiencies, but also there could be non-critical sequences of work that were also impacted due to disruption issues. And what one would expect to see would be, particularly on international projects, where you need a large supply of labour, and that supply of labour is not there anymore. That may well impact productivity going forward due to the COVID event. You may also see restrictions in terms of the numbers of individuals that could be on any one site compared to what would normally be there. And also, as we discussed, lack of materials impacting the buildings. So all of these things could well, whether critical or non-critical, give rise to disruption claims.
Thanks, Martin. Just given the time, Sanjana, I might just move back to you to talk about second waves and the continuing pandemic and impact on entitlement, because I think other than the other majority of questions were really just on second waves, or third or fourth in some countries.
Thanks, Gitanjali. In fact, many in the audience had questions on delay and disruption claims, since most jurisdictions have not seen one, but a few waves of COVID-19, with differing restrictions being imposed by authorities each time. So this has naturally led to a lot of discourse on whether each wave or relating restriction amounts to a new event or a continuing event, and what that means for entitlement. When is there effectively a break in causation? So Raj, I'd like to start with you here. Could you please share your views and comments from an Indian law standpoint?
Sure. So, as you know, several countries now at this stage, especially in UK and Europe, are going through the second wave. And there is a disruption already taking place there. Parties are in a bit of a state where, when they'd already resumed their work and after the first phase was over, they are now staring at a second phase of lockdown, which is even harsher than the first stage. Now, there is a larger issue whether essential services are being blocked or all services are being blocked. So that's a different story as to what all is permitted even during the second phase of lockdown, and that needs to be looked at. However, in India, we've seen that India has rather been on a reopening phase, so we haven't seen that second wave restrictions coming in place. So to that extent, India has been fairly fine with reopening stage, and the work has already started to commence. But what is important to see is that whether when you hit the first wave, you invoked, a lot of the clients invoked a force majeure event and said that it's a pandemic event, we could not continue with the project, we cannot go ahead with the project. And as soon as the first wave ended, people started resuming work and started getting back into action. And there came a second wave. Now, it's also important to see whether it is whether second wave in any sense restricted you from continuing your work, whether in the second wave, could you anticipate the second wave? And if you could anticipate a second wave, could you mitigate the factors that you may come across in the second wave? Was there a reasonable sense in the market that there is likely to be a second wave? Could you mitigate that position after you resumed work? Now, there are a lot of other parameters that will also have to be looked into, because the courts and the arbitral tribunals are going to look at them on a case-to-case basis to see whether any restrictions during a period affected them from completing their work or did not allow them to complete their work. A lot of it is going to be what steps could you take what were the precautionary stage that you could take. So these are going to be very important questions the court will look at. In fact, they will also look at the nature of restrictions previously imposed and its effect on the businesses. The court will also want to consider the nature of businesses itself and the extent to which it was affected due to the first round of restrictions. The nature of restrictions in the second round, were they stringent? Were they just carried on? The earlier round was carried on to second round, or there were further restrictions that were in place which impacted them from and the impact of the additional restrictions on the subsequent work and during the subsequent lockdown. So these are all questions which will be very important for the courts to consider while they are going to consider the claims on additional costs.
Thank you very much, Raj. I mean, I completely agree that despite the ongoing pandemic, the Indian government has gradually lifted restrictions, and this would definitely have a huge role to play when the claims are being decided by courts or arbitrators to see the degree of impact of these restrictions, if any, on the particular project or the sector. Paul, over to you. Contrary to India, UK finds itself in a strict lockdown. So how are parties viewing this? How are practitioners viewing the recent COVID wave and relating restrictions? Is it considered a new event? And what's the impact on entitlement?
Yeah, so it's a good question. I mean, I think sadly we're probably in our third lockdown in the UK, so arguably on third wave, and actually many parts of Europe are similar, but certainly a whole new set of challenges. And I think, you know, legally complicated is again the answer. The force majeure position is a bit tricky because you know, the second wave in a pandemic, is it all part of the same pandemic? Is it an entirely new event? That's quite tricky to identify. But I think also in relation to that sort of force majeure angle, a lot of those provisions are really aimed at you know, works coming to a halt and what the consequences of that force majeure and the suspension of the works effectively are. So it's got to be questionable, given the context I talked about earlier, whether or not that type of entitlement really does help contractors at the moment. The change in law position is I think a little bit more clearer, whilst it's also complicated. So I mentioned earlier that there's been a lot of regulations issued in the UK. I think we've done a count, and we think there's 64 different changes in the regulations in the last 9 months as to how to act during the course of the pandemic. However, the construction industry, since that first phase I talked about right at the beginning of the webinar, has kind of settled down. You know, the guidance as to whether construction industry should continue has been pretty stable since probably around about April, and that's been the same through that first wave, the second wave, the third wave now. There remain those regional differences between England, Scotland, Wales, and Northern Ireland, which is a big complication. And more recently, you know, there's been talk in the UK about moving to from the 2-meter social distancing rule, which has generally been applied across construction sites as well, wherever possible, to a 3-meter rule, which would obviously be a significant change. But each of those new regulations, insofar as they create some impact for the construction projects, then I would be saying to clients, you know, contractors, you should be getting a new notice in, because there's no downside really in getting that new notice in. You want to make sure you're protected. You want to make sure you don't lose entitlement just on a technicality of not having served the notice. So I think there probably are new events, but it's a difficult balance between the points Martin was talking about and the legal points. You know, there's the theoretical entitlement under the contract, and yes, safest to notify potential new events, but you still need to track through what the actual impact is, which in UK is very different. Just on a point there, in terms of, I mentioned in 64 different changes of regulation in the UK. If you have a contract which talks about change in law, which is more broad than just the project site, for example, not only would you have to stay on top of all that guidance relevant to a UK project, for example, but if you've got international supply chain, international workforces, understanding the impact of those potential changes in different countries, you know, is a hugely difficult task to really demonstrate entitlement. So I think, you know, the second wave, the third wave is relevant not just necessarily to your own jurisdiction and the jurisdiction of the project, but you also have to think more broadly and make sure, if you're the contractor side, that you're getting your relevant notices in just in case, so that you're protected and you don't lose that entitlement.
Thanks so much, Paul. And that actually ties into my next question to Richard. Since Australia has been largely protected from the virus, and I'm sure most of these discussions may seem alien to you, or rather these struggles may seem alien to you, but what is the impact of the subsequent COVID-19 waves in other countries or international infrastructure projects in Australia? Are they being viewed as continuing on new events, and is there any impact on entitlement?
Thanks, Sanjana. That's a really interesting question, because of course, Australia is effectively COVID-free, the consequence of which is beyond safe work practices, which most employers are insisting upon. The consequences have been still direct in some instances, particularly supply chain. Interestingly enough, supply chain effects from places you wouldn't ordinarily expect. So particularly in a mining and natural resources heavy place where I work from, specialist kit out of northwestern Europe is particularly difficult to come by at the moment. We are experiencing real challenges around technical labour getting into the country, let alone an Indigenous workforce that can't move between states and territories in some instances. So the effects are still direct, but the question of entitlement is going to be much more nuanced and subtle. And there's going to have to be real thought put into how do you actually prepare and pursue a case of that sort or a claim of that sort when there's no real direct impact at the work site. And how that's being grappled with varies. There's no doubt that you've got some employers taking a very practical perspective, but that is a shared pain perspective. And you've got others who are saying, I've got a contract and you're going to have to do your work, contractor, in order to demonstrate entitlement.
Thanks so much, Richard. I'll let Gitanjali to take it forward from here. Gitanjali, I think you're on mute.
Yeah, I'm back on now. Sorry about that. Thanks, Richard. So that just takes us to then what you just talked about, the industry practice and the lessons learned. And I thought, Venkata, given you're coming from the other side of it, which is, you know, as an industry participant, with the lessons learned over the past year, what are some of the specific practices that your business is now going to adopt to mitigate the time and cost impacts of COVID-19? And importantly, if you were to give one piece of advice to the other contractors or employers who are in the audience today operating in these sectors, what would that be?
Gitanjali, I think everything boils down to good contract administration, the old principles, you know, have a clean communication with the employers, timely communication, follow the notices, the process that is contemplated in the contract. That is the most important thing. I think ultimately, if the dispute lands up in lawyers' table like you, and you have to take it forward, you would appreciate that arbitration is very, very fact-centric, right? The facts matter a lot. Even for the delay analysis to happen, it's the facts that have to be recorded appropriately. I think that is where my one piece of advice would be: keep the communication, keep the claim intact, both entitlement as per the contract, as per law, because as of now there is some kind of ambiguity and there are differences of views, which clause to be invoked and which clause not to be invoked. And also with regard to in India, I think it's very important to know that certain legal rights cannot be given away by a contract. So we'll still be entitled to certain legal rights. I think that's the most important lesson. And I am very strongly in favor of invoking the change in law clause. The reason is, I think I'll just take a minute to explain why this change in law clause actually comes in. When a contractor is bidding for the project, he can bid it the best, most scientific price he can bid. Because there is a PV formula which takes care of price variation, and it is for the employer's benefit that all the bidders can put the best price, and all the eventualities like change in additional tax burden because of change in law, or additional requirements because of the law, is taken care by the employer. So that is precisely the reason. I think if you know the background for what reason the change of law clause has come in, I think the contractors have a very strong reason to press for a claim arising out of change in law. And I think the key lesson is to keep the communication intact, timely communication, follow the process, maintain the risk registers, hindrance registers at the project site, which is signed by all the parties.
Thank you. That makes sense. And Martin, do you have anything to add from an expert's perspective? I think very similar views, I would assume.
Yeah, absolutely. It's interesting. One of the things that we've all discussed today is the evolving situation that we're all faced with. And we could have local issues changing on a daily, monthly basis in terms of how COVID is impacting us locally. But on large international construction projects, given the different waves and the different ways that various countries are dealing with COVID, all of those impacts can feed into large international construction projects at different times as we move through this process. And so going back to what Venkata was just saying, facts are everything, and recording facts and keeping on top of the facts and recording what's going on is so important. Any good delay analysis relies on good factual evidence and good programming evidence. Given the ongoing nature of the pandemic, then obviously, as Venkata was saying, we need to, clients need to be putting or contractors need to put their notices in. But regardless of whether you're working for a contractor or an owner, you should be constantly monitoring the progress of the works, recording delays, and accurately assessing the impact of these ongoing issues on the progress of the works. Because as I was saying earlier, context is everything when analysing delay. Context of how a project is in month 1 in the process of looking at COVID may well be very different to how we look at it in month 5 or month 6, because something else might have happened. It may have been a major issue in being able to get a piece of kit from a certain country to where the project is. So it's an ongoing situation. So facts are everything. Assessing progress and monitoring progress is so important. And keeping an eye on the programming data will be extremely important.
Thank you, Martin. I know we are all actually now at time, but I thought rather than if we can very quickly take some of the audience questions that have come in. There've been quite a few, about 15 questions, but I'll just pick a couple which I think we haven't touched upon. So one of the questions is about when you have no relief under the underlying contract, is there a trend towards agreeing to a more fair response? So this question kind of goes to, are you seeing that people are trying to find a resolution, contractors and employers, say for agreed site suspensions or some risk sharing approach? Are you finding that they are more open to this now at the moment than they would have been in the past, given that this COVID-19 is a commonly shared pain? So I'll open it to any member of the panel who wants to take this.
Well, I can start off. Unfortunately, the situation is, I haven't reached a stage that there is a resolution of the claims, especially the most contentious claims. There are instances of this is all in theory. The parties have to act in the best interest of the project. Each side should not take, undue advantage of the situation. All these are in theory. In reality, what is happening? I think in reality, there is no hard stand that is taken. At the same time, the determination is not happening, especially with regard to some contentious claims. But the government has given certain guidance, and based on the guidance, some employers have considered the labor charges and the site charges, the labor site charges that we have incurred. And they also asked us to submit certain documents, and we have submitted those documents. But I'm sure it's not going to be decided so soon. There's a long way to go.
Thank you. Anyone else want to just add anything to that? And I'll take one more question after this.
I would just add something, Gitanjali, if that's okay. So I agree very much with what Venkat said. I mean, I think everyone accepts generally that COVID-19 is kind of a no-risk event. It's no one's fault, and so there is a general openness to negotiate in circumstances where perhaps there wouldn't be otherwise. That said, someone still has to pay the bill, and that's the issue. And what Venkat was talking about, it is really about, it depends very much on the project, the stage of the project, perhaps the relationships between contractor and employer, how well established they are, whether it's framework type relationship, so there's so many different factors that are involved. And a negotiated result on one project might well be achievable, but it very much will depend, even to the degree of the individuals, the project manager, the engineers on site and their relationship. So it's there are no hard and fast rules, as Venkata was saying, really.
Thank you. Just related to that, so just with and sort of tying to our lessons learned, are there now, in terms of negotiating the contracts, would you advise for certain provisions that should be included for in order to cater for a pandemic, whether it's and what type of provisions are you seeing that are now being formulated to cater for what has happened? Any of the practitioners?
Well, Gitanjali, let me tell you, I would like to answer the first question and this one together. In India, where the largest employers are the PSUs, there is no way they are going to negotiate and give you anything. They will say that you please go and arbitrate and get your money. There can be discussions, but there will be no solution. They will accept, but they will not be able to, because they don't want, they will retire at the end of the day. They do not want a vigilance being done on them to say that there has been some corrupt practice. So if somebody is of the view that there will be a discussion and there will be a solution, forget it. That is practical reality. Now, as far as pandemic is concerned, it is nobody's fault. The employer and employee should now, the contract should have what I would put together. The employer is setting up a project to earn profit therefrom, right? Now the employee, it is in employer's interest to complete the project as fast as possible. Maybe they can introduce a bonus clause, and if the contractor is able to catch up on the revised schedule, they can share the benefit that would be derived, say 40-60, 60-40, whatever ratio they think, and that bonus provision would entice a contractor to perform well, perform quickly, bring about processes of acceleration. There are people like Venkat who knows how to accelerate, who will do whatever is required. Otherwise, Venkata knows that at the highest I will suffer by 10% of delay damages. So he will keep on chasing and fighting for his right. And at the end, it is the employer who will suffer. So my view is they should create a win-win situation for themselves. The employer should come out with innovative solutions of giving bonus to the contractors in such circumstances where it is nobody's fault. Maybe that is where you will see the industry moving in a completely different direction. This is my view, of course.
Sure. Anyone else would like to add, Raj? Sorry, Raj, you're on mute now.
Sorry, I quite agree with what Sudeep just said about the settling in with a government organization is not going to be easy task in India. It's going to be extremely difficult for the reasons that he rightly mentioned. But if you would also see that most of the contractors are not initiating action at this stage. They are not jumping in to start any litigation because they are hoping that maybe they can complete this project. Maybe there are subsequent projects in line which they are also looking at. So they are not wanting to initiate action in one project so that they are blocked for the subsequent projects, or there is some blacklisting happening where they are not going to get the subsequent projects. So some of the contractors are also taking some practical views and saying that I may lose a small amount right now, but I may be able to cover it up in my subsequent projects or a next project, which I may be able to get from the government. Now, this is again a practical view that's been taken. But yes, most of these claims I would see probably, if the matters are not getting resolved, would start coming nearer to its limitation time. And you will see far more litigation starting then, nearer to the limitation period coming to an end.
Thank you. Thank you, Raj. I think we have one insurance question, which Sanjana, I think you can ask Richard, as being our construction and insurance guru amongst us.
Sure. So Richard, an interesting question from the audience is that could we cover contractor losses on account of COVID into any kind of insurance?
Yeah, fascinating question, Sanjana. Look, it may well be possible. If you look at the test cases that are being run out of London at the moment under various ISR policies, there's no doubt that careful considerations being given to policy operation where you've got business being disrupted. There's also no doubt, I think, that the courts are taking a sympathetic view to policyholders. That said, the real challenge with all of that is if you've got an existing policy that's pre-pandemic, you ought to be canvassing and reviewing the wording very carefully, because you won't find COVID-19 mentioned anywhere. I guarantee you, if you've taken a policy out post-March 2020, you will see in bright lights the words COVID-19. The consequence of which insurers have shut the door rapidly on the idea of creative lawyers and insurance brokers and policyholders pursuing weird and wonderful claims in order to make up the gap between a contractual position and what might be available under insurance.
Thanks, Richard. Does from the Indian point of view, is there anything to add on the insurance side? Just as a final, we have already 10 past, so just the final question.
I think what Edward said is something similar that we seeing it in India as well.
Great. Well, we're 10 past, but this has been I think we've canvassed and covered quite a lot in this webinar. I hope our attendees have enjoyed listening to our speakers. learned a lot, and I've actually been getting messages from some of the attendees that I know that this has been quite a fascinating webinar, and a lot of people are going to go away and probably rethink their claims or the way they're doing business. So thank you so much to the panelists. I really appreciate the time that you've put in, especially given the variety of time zones that we are covering. Thank you also to my co-moderator, and thank you to the attendees who have been very active in asking questions, and we've thoroughly enjoyed answering their questions as well. Thank you, everyone.
Thank you, everyone.
Thank you. Stay safe.
Thank you so much.
Thank you.